Today we are going to take a look at a decision from Germany again. And this is a case where the focus is placed on the issue of willingness on the side of the implementer, particularly looking at what type of behavior can be expected from an implementer after there has been a notification that there is infringement of SEPs and the license needs to be taken. This is the focus of the decision, but apart from that, some other interesting topics are covered as well. One is the conditions or the requirements under which a potential abuse of market dominance can occur with respect to filing an actions filed based on SEPs. And also there are some interesting remarks of the court regarding the non-discrimination issue. And finally, there are also some remarks of the court regarding the extent of an obligation to disclose documents in front proceedings in Germany, especially agreements with third parties which have already been signed. So this is what we're going to talk about today. The decision is a decision of the District Court of Munich, which was delivered in February this year. And the claimant here is GE, which is also here a member of the so-called Access Advance pool, which is a pool covering patents, standard essential patents, especially with respect to the HEVC standards. So we are here talking about codec and not wireless standards. The defendant, on the other hand, is TCL. Before we go into the legal part, let's take a look, as always, at the story behind the case. As we're going to see in a moment, the most part of the discussions between the parties, or the negotiations between the parties, were led between the pool, the Access Advance pool, and TCL. There were also bilateral discussions between the patent owner GE that had filed the action here and TCL, but that happened at some later stage of the case, especially after the proceeding started. So most of the discussions were between the pool and TCL. And the first contact was already back in May 2016, that is more than 7 years ago. There, Access Advance contacted TCL and informed about the portfolio and offered discussions and negotiations for a license agreement. Initially, there were some communications between the parties, which, however, did not move very fast. There was no agreement signed. Then in 2018, Access Advanced shared claim charts with TCL. What was interesting here is that this was also a bit difficult because it took 7 attempts to send the claims charts over to TCL. And we're also going to see later on that this was something noted by the court. And apart from that, there was also a meeting in person with a representative of TCL. And during this meeting, the TCL representative informed Access Advance that they were speaking only for the TV branch of the TCL group, not for the smartphone and tablet branch. And this was a different company, but they did not name which company this was. So Access Advance had to identify the company and also start a separate line of discussions with them as well. In July 2021, then Access Advance in March 2020, Access Advance provided the standard license agreement of the pool to TCL and sent again 25 claim charts. But at that stage, there was no agreement between the parties. So there were further discussions going on. In early 2021, then TCL and both branches, the smartphone and the TV branch, basically said that they would need more time to assess the information they had received so far, and especially they also mentioned that they would need more time to work with the claim charts, that they have not been through the claim charts yet. So shortly after that, GE brought the present infringement action against TCL before the Munich District Court. So this was the stage, basically the years before the proceedings started. After the proceedings started, TCL had been a little bit more cooperative, and as we're going to see, it made also to counter offers to the pool. Before that, the pool made another offer to TCL, both for the smartphone and the TV branch, which was on, let's say, lower, better terms than the standard agreement that has been provided in the past. This was not accepted. In October 2021, TCL made a counter offer, which was also rejected by Access Advance. What happened also almost at the same time was that in the proceedings, Access Advance provided TCL with access to third-party agreements over a data room that has been established for this reason. Initially, they provided 43 agreements in this data room out of almost 216 total, and then more agreements were added. So at the end, there were 61 agreements offered to TCL for review. Almost at the same time, TCL's attorneys in the proceedings wrote a letter to GE and asked GE also for a bilateral license agreement offer. So this was then the start where also GE was involved as the patent holder in the negotiations, and there was, let's say, this second layer in the negotiations between GE and TCL. In the following, there were further offers sent by Access Advance. There was an offer in March 2022, which covered both the smartphone and the TV branches of TCL, and there was an amended offer a month later, which was then on a lump sum payment following a request of TCL, but this offer was not accepted as well. At the same time, GE made also a bilateral license offer to TCL, which was not did not lead to an agreement either. What was interesting here and also played a role in the decision later on was that regarding the offers that were at the table in the spring of 2022, an offer by the pool and also the bilateral offer by GE, TCL responded only to the first of them. So it made a counter offer only to the pool. A counter offer to GE was not made at all by TCL. So this was the status during the proceedings, which were concluded with the decision of the court in February 2023, which found in favor of GE, of the patent owner here. And among the other remedies, the recall and destruction of infringing products, etc., also an injunction was granted against TCL. Now, we have not been able to identify whether this case has been appealed, but of course we will monitor the case law, and if there is an appeal decision in these proceedings, we will include this, of course, in our webinars here. So this was the story, and now let's take a look at the legal findings of the court, of the most important remarks which the court made in this case. The TCL raised, of course, a front defense here, and in Germany, this front defense is predominantly based on competition law, on a competition law angle. So what the courts regularly examine here is whether through filing the action which is directed into an injunction or the recall and destruction of infringing products, basically to claims that can exclude the implementer from the market, whether this would constitute an abuse of market dominance on the side of the SEP holder, and if this is the case, then an injunction or other exclusionary measures should not be granted. So this is what the court in Munich had to also examine here. The first thing you need to clarify here is whether there is a market dominant position on the side of the patent owner. In the present case, the court assumed that there was a market dominant position, although this was something that was contested between the parties, but the court just assumed that, mainly because it found that very clearly there was no abuse of a potential market dominant position here. So the court said here an abuse is given if there is a request to have access to an invention which is patented, and the SEP owner either denies this requested access, so does not want to grant the license at all, or offers access at unreasonable conditions. And it is important also to add here that an abuse is there if this unreasonable, if the SEP owner is not willing to depart from this unreasonable condition until the end of the negotiations. According to the court, this means that a non-front offer which is made during the negotiations, maybe in at an early stage or even later on, does not per se mean that there is an abuse of market dominant behavior here. So this refusal to grant access to reasonable conditions needs to be there even at the end of the negotiations. In the eyes of the court, this was not the case here. The court found that there was no abuse of market dominance on the side of GE because mainly it found that TCL had not been sufficiently willing in the negotiations with the pool, of course, but also with GE. And this missing willingness was there both before and during the trial. So this was the court's thinking regarding this potential abuse of market dominance by GE, by the SEP owner here. And then, of course, the main part of the decision focused on exactly this issue, or the issue of willingness on the side of TCL. Now, generally here, the court did not apply something new, did not apply a new standard. It applied the standard that the Federal Court of Justice, which is the highest court in Germany, has set in 2020 in the Siswell Hire cases, which has, let's say, two elements. One element is that on the implementer side, a clear and unambiguous declaration of willingness is required on the one hand, and additionally, the implementer is expected to show a target-oriented engagement in the negotiations with the patent owner. So this is the general framework which the court followed here as well. But in light of that, it made several remarks or clarifications which are very interesting. The first one was to say that this request to sign a license on the side of the implementer, or the willingness on the side of the implementer, must be continuous, meaning that there should be a real interest into obtaining a license, and this interest should be there throughout the negotiations of the parties. The court linked this requirement also to the question of the abuse of potential of a market dominant position, arguing basically that if such a willingness is missing, or a sincere request to sign a license is not there, then basically an abusive behavior on the side of the SEP owner is also regularly excluded. Because in order to be abusive, you need to have on the other side someone who is actually willing to engage and to take a license. If this is not the case, then it does not play as much of a role what the patent owner is doing himself. So this was an element which the court highlighted here. As other courts have said, when you are looking at the willingness of an implementer, you have always to have a case-by-case assessment based on objective criteria or from an objective viewpoint. This means that you have to consider the circumstances of each individual case and how the parties have acted in the specific scenario. Meaning that you cannot have, for example, let's say deadlines which apply to everyone when a response should be there, etc. It's basically needed to take a look at the circumstances of each individual case separately. What the court said here is that in order to look whether there has been willingness or not, there is mainly one question that you should answer. And this is the question of what would a reasonable party which is interested into reaching a negotiation outcome that serves the mutual interest do in the specific stage of discussions in order to promote this goal, again considering the specificities of the individual case. So what the court should do was basically to look at what could be expected by a party which is indeed interested into signing a license in the specific case between the specific or similarly situated parties, considering the way the parties have already behaved so far, and then compare that to the actual behavior of the implementer. And if there are discrepancies between them, then of course it's very likely that there is a lack of willingness on the side of the implementer. Apart from that, some other general comments which were interesting here was the clarification of the court that willingness includes also a duty to promote negotiations. Meaning that it's not just about sitting together or joining meetings or discussing, basically. There is a need also to work in a way which can lead the negotiations to a conclusion. The court said here that this duty to promote negotiation is triggered every time when during the negotiations, it can be expected from a party, from the implementer, particularly here, to make the next step, to take the next step. And how to assess that, you have to look at the usual business practice and also the principle of good faith. Meaning again that you don't fulfill your obligation to act as a willing licensee by just taking part in discussions, but you have, for example, we're going to see that also more in detail in a moment, take the information that has been provided, process this information, and let's say make suggestions based on that, offer changes, etc. So this is a duty to promote negotiations, which is part of being considered a willing licensee. Apart from that, if there is a offer on the side of the SEP owner, the court also said here that there is a duty of the implementer to react to this offer, which also includes a duty to raise all concerns against the offer at once, meaning not waiting for to raise concerns later on, especially waiting to raise concerns if litigation starts at a later point in time. And this duty to react is regularly given. So irrespective of whether the offer is perfectly front or not. There is one exception when there is no duty to react, and these are cases where the SEP owner's offer is absolutely unacceptable. Meaning here, this is a high threshold, cases in which the offer is so bad or so far away from the front range or the front threshold that you cannot really see a seriously meant offer in this offer of the SEP owner. In this case, then it is allowed, or it's acceptable that the implementer does not react at all. But apart from these extreme cases, regularly the implementer is obliged to react to an offer by the SEP owner. And this goes back, of course, to this requirement to engage in a target-oriented manner in the negotiations, because if you would expect to react only when the perfect front offer is there, then of course negotiations could not move forward. Then the court also made a point regarding an issue which is often encountered in front cases and was also an issue here. And it's the question of how to deal with cases where the implementer at an early stage has been unwilling, but at a later point in time had a change of mind and actually was interested into getting a license and moved constructively to this end. Is this something that can be considered, or is this something which is irrelevant? And the court said basically the missing willingness can be compensated at a later point in time. However, you have always to look at the specific circumstances of the case, and especially how the implementer behaved before, or how, let's say, strong the unwillingness was before. And for example, in the present case, as we're going to see in a moment, the court found that TCL was not able to compensate its initially unwilling behavior later on during the court proceedings. Finally, one element here, which is also interesting, more from, let's say, procedural side, the court said that if the unwillingness of the implementer is established, then the court is not going to, or should not, examine the offer of the SEP owner in detail and whether it's front conform or not. This is something that, again, was established by the Federal Court of Justice in the civil hire cases, and was adopted by the District Court of Munich here, meaning that if there is a finding of lack of willingness on the side of the implementer, there is no need for the court to examine every detail of the SEP owner's offer and also reach the conclusion that this offer has been front. And this is something which the court did also here. It did not go into the details of the offers that have been made to TCL. Now, what are the principles which the court? Now let's take a look at the assessment, the specific assessment of the court here. So as we have said already, the overall conclusion was that TCL was not sufficiently willing, and this was both before and after the action was filed. The court here took into account the entire conduct of TCL, and the entire conduct both towards the Access Advance pool and also towards GE. So it considered how TCL had behaved both towards the pool, mainly before the proceeding started, but also towards GE after the proceeding started. The general sentiment of the court here was that TCL applied delaying tactics. The court found that TCL's goal was to impose its own financial licensing conditions, and that it had intended to use the patent without authorization and payment of fees for as long as possible, basically in order to create pressure on the patent owner side. What the court also mentioned here, and this is, I think, an interesting point, is that this unwillingness of TCL is also shown by the fact that although it got access to third-party comparable agreements and had argued in the proceedings that competitors or other similarly situated licensees had gotten a better deal, at no point in time had it demonstrated from an objective viewpoint a willingness to take a license on these allegedly better terms, which were signed by its competitors. And this is an interesting view here, because the court basically said if you are complaining, or if you are arguing that the offers you got were not good enough, or not good enough, or so good as the offers that or the deals that other competitors have gotten, then it is at least expected that you would be willing to accept the terms that you think are better. And if you, with your behavior, do not show that, then this can be also an indication that you're basically unwilling in general to take a license. And this is something which the court saw this way here in the present case. Then the court also mentioned here that some of the criticisms which TCL had raised with respect to the pool licensing conditions did not justify its behavior and did not make its behavior less unwilling or willing. There were basically two elements which TCL had raised with respect to the pool licensing terms. Aspect of the topic of discrimination, which we're going to take a look at in a moment. It basically said that one element was the so-called duplicate royalty policy, which the standard terms of Access Advance included. And this is going back to another decision in parallel proceedings led by Access Advance in Germany, in Düsseldorf, where the Düsseldorf court had found that this duplicate royalty policy, which is part of the standard terms of the Access Advance pool, was not France because it did not contain sufficient safeguards to make sure that an implementer who has licensed patents through the Access Advance pool, but eventually the same patents also through another pool, will not make double payments for these patents that as long as there is an overlap between the different pools. And this was also an argument raised here by TCL against the offers by Access Advance. But the court said this argument did not really convince here because TCL did not show that it had already licensed relevant patents otherwise. So even if this provision would not be sufficient, factually there was no real issue here because TCL had not licensed any patents which are included in the Access Advance pool. So this was not a significant issue here. The second element was TCL's argument that the pool administration fees are very high, and which makes then the offer unfront. And here the court did not go into the merits to examine that. And the main reason for that was that this was raised at a very late stage of the proceedings. So this was raised almost after 6.5 years after the terms were delivered to TCL. And the court said here that it was not warranted to stop the decision of the court shortly before it would be delivered and reopen, let's say, evidence on this topic because this would just cause further delay. So this was again something which the court did not see that it could change its view regarding the finding that TCL had acted as an unwilling licensee. Now, to be more to look more at the behavior which the court criticized on the side of TCL. Before litigation, the court focused on several aspects, especially the reaction of TCL to communications by the Access Advance pool. So we have seen in the beginning there was the notice of infringement and some discussions took place, but shortly after that, after this initial contact, TCL was more or less silent for a period of time. So the court mentioned here as a potential, as an indication of unwillingness, the fact that after this initial contact, TCL did not react at all to 10 emails and 9 letters sent by the pool to different companies of the TCL group. So this was one element the court criticized. Then another element which the court criticized as well was the fact that Access Advance tried to provide claim charts to TCL, but delivery of the claim charts failed 7 times due to technical problems at TCL. So the court was also looking at that as a potential way just to delay negotiations, and mentioned this with respect to the assessment of willingness before the start of the proceedings. Then the other element which the court mentioned was the fact that after there was this first meeting, and TCL informed the pool that the specific representative was not just speaking for the TV branch and not for the smartphone and tablet branch of TCL. It was not mentioned which is the company within the TCL group which is responsible for the smartphones and tablets. And this was mentioned also by the court here as something which indicates unwillingness or an intention to delay. And of course, the last element which the court noted here was the fact that both TCL branches, the smartphone branch and the TV branch, did not review or did not examine the claim charts received months after they received. So here the court also saw an indication of unwillingness. Then during the proceedings, the question here was, did the things which TCL undertook during the proceedings, did they compensate its previous unwillingness before the start of the trial? And the court in general said no, because it found that TCL acted too late and engaged too little in general. There were here two elements which the court highlighted. The first one was the constant requests for further information that TCL raised during the negotiations. The court said, of course, when we're talking about front licensing, it's not prohibited to ask questions, or it's not prohibited to request information. But the court said this can be problematic if such requests are repeated very often and after many years of negotiations. And especially it can be problematic when the information received has not been processed and has not been used in order to progress the negotiations. And in the eyes of the court, this was something that had happened here in the present case. The court mentioned some examples. First example was that TCL did not use the data on the comparable licenses that it had gotten through the data room, which the Access Advanced pool had established in order to provide concrete feedback on licensing terms. So what the court would have expected here is that TCL would look at the agreements, look at the specific terms, and then come back to the pool with specific proposals on how to change things, how to change licensing terms, add or amend, etc. But this did not happen. So here the court said requesting further and further information on the comparable licenses without really this being mirrored in proposals regarding the terms is something which is problematic. Then what the court also mentioned here was a motion which TCL filed during the proceedings. And it was a motion requesting the court to order the disclosure of non-redacted version of the comparable agreements that had been offered to TCL. So there were some reductions in the agreements that were shared with TCL, the comparable agreements. So TCL requested to have access to the full agreements without reductions. But the court said that this was something that was filed approximately 10 months after access was granted to the license agreements. And this was a request for additional information, which did not really make sense, not least because it was filed so late after the information was received. So this was something that the court also criticized here. And what was also criticized by the court was the request filed by TCL, also with a specific motion towards the court, as we're going to see in a while, to disclose the internal pool agreement of Access Advance with the individual SEP owners that are part of the pool. So the court saw here again a request to have additional information, but was not really convinced what was would be the relevant of the information contained in the internal pool agreement for the case here or to TCL. So this was also seen as a potential attempt here to delay things. The second element which the court then looked at in the phase after the proceedings had started were the counteroffers which TCL made. And the principle behind that is basically to say that, of course, if an implementer makes a counteroffer, it makes clear that it is prepared to take a license on the terms that are contained in the counteroffer. So this is something that could indicate the general willingness to obtain a front license and to negotiate with the patent owner. So this was something that needed to be examined here, whether you can extract, let's say, willingness out of these counteroffers. Of course, this applied only towards the pool, because as we have seen, TCL had not made a counteroffer to GE after it had received the bilateral offer of GE. So it was only about here whether the the counteroffers of TCL towards the pool could have this effect that they could contribute to consider TCL as a willing licensee here. But the court found that this was not the case. And it had concerns both in terms of timing, but also in terms of content. So in terms of timing, the court mentioned here that the first counteroffer was made after almost 1.5 years. So this seems to be quite a lot of time if for someone who is actually interested into signing and taking a license. Apart from that, the court also found that in terms of content, the conditions which were included in the counteroffer, the first counteroffer, were impossible to be accepted by the pool, both structurally and legally. What does this mean? The court basically saw that the royalties for future sales, which TCL counteroffered, were so low that if the pool had accepted to license TCL on this very, very low terms, then it would likely violate its own internal bylaws and the agreements that it had signed with the SEP owners. So this was something that the pool would not do, and of course, this also meant that you could not expect the pool to agree to this counteroffer. Then the court, in this context, it mentioned also as a sign of unwillingness the fact that the amended counteroffer, which came shortly before the end of the proceedings, had no substantial improvement regarding this part. So here the court also said the terms were very low and were not also improved in the second counteroffer. So this indicated again a missing willingness and rather an interest to delay things. Then finally, the court also found here that in any case, TCL was not entitled to the conditions which were included in the counteroffers, not least because these terms would conflict with the disclosed comparable licenses, meaning that they would be very different from the terms that other similarly situated licensees and competitors of TCL have signed. So therefore, there was no claim. TCL could not claim basically to be granted these terms. So offering these terms again was not justified. So, having said that, the court then had this looked at the SEP owner's offer, not in detail as we have said already, but only with regard to this question, which is linked to the assessment of willingness of whether the offer had been absolutely unacceptable or not. And here it took consideration of both the offers of Access Advance, but also the offer of GE. Again, this is not a full assessment of the front conformity of the offers. It's just an assessment of whether they have been extremely unfront or extremely outside of the front frame. So with the consequence that the assessment of the willingness of TCL should have been different here. But the court found that this was not the case. It it said, of course, that the SEP owner must be willing to offer front terms, and that it's in general unacceptable to offer and insist on arbitrary or discriminatory conditions. But it did not find that any of these extreme conditions or extremely unfront conditions were included in the offers that TCL had received by both the pool and the SEP owner here. The main issue here was the issue of non-discrimination. And this goes back to TCL's arguments, which revolved a lot around this topic, basically saying that it got offers which they could not match the offers that others had gotten, and were much worse than the terms that other competitors had signed. So the court took a look at that and made some clarifications in this respect. It said basically a discrimination can occur, and this is the case when you treat equals unequally or unequals equally without justification. So this is the case. If this happens, then you have a discrimination, and the terms offered are not acceptable. If we are in a litigation context, however, the court said here whether this is the case or not is something that the implementer must show and establish in the proceedings. So this is the duty of the implementer to show that the offer has been discriminatory, not something which at first is an obligation of the patent owner. So here in the present case, it was on TCL to show that the offers of the pool and GE were not were discriminatory, and for that it should have provided at least plausible indications. But in the eyes of the court, this had not taken place here. So TCL failed to do that. The court looked at different aspects here. And one of the aspects was based on the same notion that we have seen before, that a willing implementer should basically be one who is willing to at least sign the terms that its competitors have signed. And here the court said in the present case there was no discrimination against TCL. TCL had claimed basically that some of its competitors or some of its of similar situated licensees had gotten better terms regarding the treatment of past sales, discounts, or not paying at all for past sales, and that the offers by Access Advance especially were not so good in this regard, and that's why TCL felt that it was discriminated against its competitors. But the court said here there can be no discrimination through different treatment of past sales if the implementer is prepared to sign a license on the allegedly better conditions. And this was something that was basically possible here to TCL, because Access Advance had indicated also in the proceedings that it was willing to discuss this point and adapt its offer in this regard. So the court said here you cannot claim on the one hand discrimination, and on the other hand do not also accept to get the same deal as your competitors if this is something that the patent owner or the pool in the present case here is prepared to do. Then a second point, which I think is also interesting here, was the finding of the court that you cannot basically establish discrimination based on comparable licenses which have been signed without litigation. So what was here the background on this? Basically, TCL looked at some other agreements which competitors had signed on different terms, and agreements, however, which were signed without recourse to litigation first. So the parties actually negotiated And as a result of these negotiations without litigation, an agreement was signed. And TCL took reference to these terms to say that the terms offered to me now are different and discriminating. The court said here you need to take into account the higher cost and risk which is attached to litigation for the SEP owner, and this higher cost and risk justify, at least to a proper extent, a differentiation in the terms. So if you are already in litigation and you have not managed to sign an agreement before litigation, without recourse to litigation, then you cannot go back and argue that agreements that have been signed without a trial have better terms and you're being discriminated against. So this is a point which is interesting and would play a significant role here when it comes to assessing non-discrimination based on comparable license agreements. And the final point here, which the court also dealt with, was whether there is discrimination because, according to TCL, the effective license burden which would occur from the offers it had received would be higher than the effective license burden of comparable agreements. TCL also argued here that the pool had acted in a discriminatory way because it had not explained why there were differences in this effective license burden between the offers it received and the comparables that others had signed. But the court here was not convinced by that. It found that this effective license burden is just a mathematical factor and it's not actual part of the agreements. And there is no obligation also of the SEP owner to explain this difference, because basically the value that needs to be compared is derived from the comparable licenses. And this is something which, as we have seen, the implementer should do, extract, and also plead in the proceedings. And finally, one element here regarding which is related to the comparable agreements, but also to other type of relevant documents in front trials. There was a motion, as we've said, of TCL in the proceedings to order the disclosure of all agreements of the pool with third parties and the internal pool agreement. So as if we remember, TCL had gotten access to the data room, had gotten access to, in total, more than 60 agreements, but it wanted to get access to all agreements signed by Access Advance, which were approximately 260 agreements. And it wanted also to have access to the pool, to the agreement between the pool and the SEP owners that have joined the pool. And the court dismissed this motion because it found that TCL was not in a position to claim this type of disclosure. Regarding the comparable third-party agreements, the court said that there is no claim to access these agreements. Why? Because as a rule, if there is a claim, the claim refers only to those licenses which are relevant to the specific licensee, and these are licenses covering the same product category or the same market. So not every agreement signed is relevant, and therefore the claim to have access to this information and, of course, to request the production, the disclosure of the relevant agreement is limited to only to relevant agreements. More or less the same was the answer of the court also regarding the internal pool agreements. It found that they are not relevant in this case here. Especially, they're not relevant to assess the question of discrimination. So here the court also denied that based on this criterion of the relevance. Finally, the court added here that there is no need to disclose documents, especially in the present case here, because TCL had acted as an unwilling licensee. And this means, the court said, even if you would have produced all of this extra information to TCL, there is no indication that this unwilling behavior that it had shown so far would cease. So this was an additional factor speaking in favor of denying this motion here and just including further information, further agreements in the proceedings, which also were not relevant for deciding the case here. The court, on the contrary, saw on this motion rather an intent to cause a further delay, not least because it was filed relatively late in the proceedings.